Okay, we'll start our class today. Uh, so this is a disclaimer, right? Okay. So what is actually your, how to say, your general advice to you is that I have read through the syllabus. In fact, I think syllabus itself is good enough for you to pass the exam pertaining to insolvency and winding up issues. I have read the syllabus and it comes to my attention that only 30 pages from CLP syllabus is really discussing for what we call insolvency and winding up. If you can sort of memorize what those 30 pages about, I think you can score pretty well marks for this subject. Okay, and your examination requirement as usually CLP required is that you have to identify the issues in the question, and then subsequently you have to bring to the attention of the examiner that you have critically analyzed the question and you have to apply the law to the facts. You cannot simply just give them a script and a hanging question without advising the party that you are asked to act open. Okay? And of course, no cheating and all that. Um, PP paper, a lot of people will have problems. And this is one of the very common paper that students tend to fail because instead of answering four questions, here you are asked to answer five questions. So virtually, you have only 30 minutes. Actually, 35 minutes is a bit stretching the time already. Okay, you have only 30 minutes for each question. Trust me, sometimes the speed of your writing may not really um within that 30 minutes. That means to say sometimes you are not so well trained to write and you write slowly, then you have problems. That's why I always advise those who listen to my class is that you must start practicing to write, not to read, especially the time is very critical here. Okay, we will discuss the first issue here, that is bankruptcy. In fact, bankruptcy, you only need to know one akta utama, that is the Insolvency Act 1967, and you have to pay particular attention to what thing is inside. Okay, for example, what is the definition of a debtor? That one very important. Okay, it will be asked in exam multiple times. Actually, if you read the question, past year question, a lot of time they'll ask you what is a social guarantor and what does it mean by the act of bankruptcy. Okay, act of bankruptcy here is referring um in exam per se, usually the person that is defaulting the judgment, after you get the judgment printout from the court, that person is still not paying. So usually this is the question about lah. Okay, there will not be concerning of the disposing of property or evasion of the responsibility from the creditor. Okay, and also the insolvency rules is actually a set of rules governing the how to make a person bankrupt. Okay, this is what you need to learn. I believe everything could be learned so long you have a method, right? In order for you to understand the question, CLP itself is a set of practical rules. So you have to like know how this process exactly take place. So what are the steps involved to make a person bankrupt? A person, you must be very sure with the word, now. This is not a sendirian berhad, but this is an individual person. Okay, first, the creditor must obtain the judgment, and that judgment must be a final judgment. Okay, so after getting the final judgment, the individual, the debtor, is still not paying, defaulted. All right. After that, what the creditor or the boss need to do is to issue a bankruptcy notice. This is your insolvency rules 89 comes into play. And then you must also take note that this bankruptcy notice has it's just like a lifespan of a REIT lah. For example, a REIT like in civil procedure can last for 6 months, isn't it? So bankruptcy notice also has got its lifespan. It only lasts for 3 months. And make for you to actually make a person bankrupt, you cannot go for other services. Like, for example, uh, other civil proceeding, we are allowed to serve the summon by AR registered post. But whereas to make a person bankrupt, this bankruptcy notice has to be served by personal service, by hand. Okay, then you have to memorize these insolvency rules and also Order 62, Rule 5, Rules of Court. And subsequently, you have to produce the proof of service. Usually, how we produce the proof of service is that we file affidavit penyampaian, affidavit of service. Let's say, for example, I have a runner in my office. That person had passed the bankruptcy notice to the defaulter. Okay, attached with all the statement of account and everything lah. Okay, and that person signed back. We take a photo, and the runner has to affirm the affidavit of service. So this is called proof of service. In the event you could not find that particular defaulter, he ran away, he evaded the service, the address could not be found, then substituted service is required. What does it mean by substituted service is that conventional by hand service had failed. So the judge, normally the timbalan pendaftar or the penolong kanan pendaftar will give instruction. What is the instruction given? Normally is to paste, there's a notice board, outside the court. If you notice, you have to put there one bankruptcy notice, and also probably you'll be asked to publish the bankruptcy notice via newspaper. Okay, so this is what we known as substituted service. And after the debtor has received that bankruptcy notice, if he raised any objection, he should reply by way of affidavit in reply. That means to say he also need to write his reasoning by affidavit and supported by exhibit. For example, what is his reason to oppose this bankruptcy proceeding? Take for example, he have paid in stages, okay? And the bankruptcy, the threshold, for example, now is 100,000 has not been met. If you don't reply at all, for example, the debtor did not reply at all, the act of bankruptcy is deemed to be committed. Okay, this is a presumption in law that if let's say you don't bother, then you commit an act of bankruptcy. Okay, then after that, what we do? The debtor can file a summon also in chamber to set aside bankruptcy notice if there are some irregularities. For example, the outstanding amount is not quantified in that bankruptcy notice, or there are some uncompliance, okay, over the bankruptcy notice. Okay. Then what will be the fifth step is that the creditor, normally the solicitor acting for the creditor, after the act of bankruptcy has been committed, they have also 6 months, 6 months from the date of act of bankruptcy to file a creditor petition. We call CP. That CP also similar, like bankruptcy notice, it must be served by hand, personal service. Okay. Likewise, you must also produce an affidavit of service as a proof of service. If that person still cannot be traced, you have to go for substituted service, the newspaper, the notice board thing. Okay. And if, let's say, for example, if you are looking at the sixth step here, the debtor can show cause. This thing can be opposed one. The creditor's petition could be opposed. Okay, by way of file summon in chambers by debtor. Okay, and then it becomes like a contentious creditor petition. Okay, but frankly speaking, I have not encountered it in my what we call in real life practice, and the set aside application will be heard here by court. Okay, if that particular hearing, the court may allow the bankruptcy to go on. That is because the merit of the case is so strong and the threshold of 100,000 ringgit owed had not been met by the debtor. They will allow the bankruptcy order. Okay. Sometimes they can also order stay and dismiss. Normally, in my case, bankruptcy order is allowed lah, because practically the bankrupt debtor, the prospective bankrupt individual will hardly turn up in the court. That's the thing. We will have an uncontested version of bankruptcy proceeding. Okay, so these are historical changes. We have moved from a few threshold, monetary threshold. Last time it used to be 30 to 50,000. Then subsequently, 2020, from 50,000 to 100,000. At the time of our discussion today, the threshold to make a person bankrupt is 100,000. Okay, that means to say if I have a judgment, okay, for example, uh, I think Sir Patiban is here, right? Okay, I owe Sir Patiban 50,000 ringgit. If take, for example, he exhausted all the enforcement against me, I have no car to be sold, I have no property in my hand, I also do not have bank account. Merely having judgment of 50,000 ringgit to Mr. Patiban, for example, is a bad luck thing lah, because he's getting a paper judgment. He can't go for bankruptcy proceeding against me personally. Okay? You must remember that lah. And bankruptcy itself is quasi a penalty. It's like you use civil proceeding to penalize a debtor. The bankrupt person is a little bit difficult in life because first thing, of course, he cannot travel. He cannot work without any sanction from Director General of Insolvency. He wants to open his account. If he receive money from his friends or his family, it can only up to the amount of meeting his daily necessity. Anything more than that, he should have declared and informed the Department of Insolvency. Okay, so a little bit restricted in terms of his financial freedom. Okay, so this is one example. Before you can actually issue, in fact, the bankruptcy order is issued by the court. To make your life easier, I will make you understand how it is done. Okay, this is one template by my law firm. Okay, before we can get a bankruptcy order, we have to send this permintaan untuk pengeluaran notis kebankruptan. That is the request for bankruptcy notice. And along with this, what we call the request, we have to submit to the court or attach annex with this request our full writ of summon cost paper plus judgment, and also we have served that judgment by the court to the debtor. All right, so this is pursuant to Rule 90 Insolvency Rules 2017. Okay, and after that, if the court is satisfied there is a real judgment against the debtor, then the service of that particular judgment had been done, duly done, the bankruptcy notice will be issued by the court. Okay, so this is the format here. Okay, and this is related to Rule 89 of Insolvency Rules 2017. Okay, so this is how then in the event of evading service, you have to apply for SS, substituted service. The one that I've told you lah, advertise, put in notice board. Okay, so if the act of bankruptcy has been committed, your previous bankruptcy notice had not been objected by any affidavit in reply, the next step you can do is to file creditor petition. Okay, petition permutang. Permutang means like I owe you money, you are my permutang, you are my creditor. Okay, like that. This is one of the format here, creditor's petition. Okay, creditor's petition. Okay, and then at the end of the day, the court will give one bankruptcy order. Like what I have told you, usually bankruptcy proceeding, yours in practical sense, you will sail smooth because the bankrupt person can't pay, can't afford a lawyer to defend him. That's the thing. Okay. And next, we want to discuss how to make a company winding up. Okay. How to make companies winding up? You only need to refer to Section 465 and also Section 466 Companies Act. These two acts talk about an inability to pay a debt on part of company. We will discuss that. And also companies winding up rule. So this is procedural. Okay. And this will be the step here. Okay. Different from individual, to make a company winding up, you do not need a judgment. That means to say, you don't need to go through the civil proceeding. You don't have to get a writ action against the company, then get a judgment, then only go against the company. No need. All you need to do is to prove there is outstanding. For example, I'm running my previous company lah. Okay. Asia Group Biopharma Sdn Bhd. Okay, my company. I owe one medical suppliers actually more than 50,000 can make a company bankrupt. I owe that company's 60,000 ringgit. And there is a statement of account, and there is also delivery orders, for example, from that medical supplies company. All they need to do is to issue a letter to me, a statutory demand, we call. Okay. This is pursuant to Section 466 of Companies Act. This statutory demand will just highlight that, okay, Asia Group Biopharma Sdn Bhd has an outstanding amount of 60,000 against ABC Medical Supplies Sdn Bhd. If I don't pay within 21 days after I receive that particular statutory demand, then they can file winding up petition in court. Then I have to appoint lawyer. Susah. Ah, and you know that by these rules of court, a company cannot go to court represent themselves without engaging a lawyer. So by hook or by crook, they need to call lawyer to step in to oppose that winding up petition. Okay. So subsequently, if let's say the companies, for example, my company default 21 days notice after getting the statutory notice, I did nothing. I sleep on it. I did not do any further action. What they'll do is they will what we call the slide is very small. Oh, is it? The slide is very small. Is it for this particular slide or what? Oh, okay. Just wait because this slide mm, but still a bit blur lah. This picture is a bit blur lah. But never mind. I will share in the group later. Later you all can see lah. Okay. So if let's say for example, okay, let me just explain to you since this what we call this slide is a bit. I will use this window instead. Okay, what you need to pay attention is two major section in Companies Act. That will be section 4651E. You see this? Circumstances in which the company may be wound up by court. Usually this is what our question. The company is unable to pay its debt. Okay, I don't care whether the company got a lot of land, got fixed deposit, I don't care. So long you are commercially insolvent, that means to say your cash flow got problem, you cannot pay whatever I have sent to you. Take for example, the medical supply I already give to the ABC medical supplies already given to me, but they don't receive money. They issue 21 days punya statutory notice, I ignore it. That means I have my companies has financial problems. This is the time where the requirement of section 4651E had been met. Okay. And the definition of inability to pay the debts had been well defined here. Okay. This one, 1A, you have to how to say you have to make sure that you know the prescribed value. The prescribed amount nowadays is 50,000 RM50,000 ringgit. If less than that figure, take for example my company Asia Group Biopharma only owe that fellow about 49,000 ringgit. Can they wound up my company? The answer is no, because the threshold cannot be met. Very important. And you also may need to pay attention to, let me use the pen. Um, okay. Let me use the pen. Okay. Okay. You also need to pay attention to this and this. Okay. These two, this winding up petition, creditors winding up petition should be filed within 6 months from the expired date of notice of demand. Okay, when this statutory notice will expire, is 21 days notice. Okay, you follow so far? Any problems? You all? Am I too fast or cannot make sense or what? Can you understand so far? Hello? Can you understand? Okay, good. Right. Resolving. Okay, let's proceed to the next slide. Okay, so this is one example of Section 466 notice. Okay, so this is normally issued by legal firm. Your future practice, you'll do like that. Okay, so usually how is that you issue against the company and then you mention this is the notice of demand. By right should be 466 lah. Okay, 466 sub rule 1 of Companies Act, and then how much you are asking for. Okay, how much you are asking for. Okay, and then important thing is this. You have to annex a copy of statement of account. Statement of account means usually the companies there is a finance clerk, a statement of account should merely showing that how much you have paid that time, how much is the outstanding. Okay, so this is like a proof of debt here. Okay, usually more than 50,000. This is the trick that will be deployed by the lawyers to force a company to pay up fast. Otherwise, problem, you have to go to court for winding up petition, which will be costly later. Okay. And this is the Surat Akuan. Okay, Surat Akuan, you have to give also. And this is apa nama? Winding up petition. If let's say the previous letter, this statutory notice, after service, remember, you can see the date, isn't it? 3rd of August 2020. And this is by hand, definitely by hand. Okay. So receive on the same day. So the time calculate after the 3rd of August 2020 plus 2. That means 24th of August 2020, we can file winding up petition if that 21 days after the receipt, the service of that statutory demand had lapsed. Okay, so this is in accordance to Rule 23 of Companies Winding Up Rule. Okay, remember that, Okay, all that will be tested in exam. Right. Okay, so this is one of the example of winding up petition. If anyone interested, I will send this copy to the group for you, your own your benefit lah. You can read it after that. So this is just a course paper lah, by the way. Okay, so something like that. Winding up petition. Okay, before you can actually proceed, before you can actually proceed. Okay, you see, for you to make a company winding up, let's say just now we have discussed the threshold is that the company is unable to pay the debt pursuant to section 4651E, correct? Let's say if I am playing some tricks here against my competitor, is it okay or not? Is it okay or not? The answer is no. You sometimes people have malicious prosecution, you know. This is give me a moment. Puan, saya call you back. Nanti boleh. Saya busy sikit. Sekejap okay. Okay. Let's say there is somebody, um, be it the director, ex-partner, ex-shareholder, want to play tricks with that particular company, they can do that now by creditors winding up petition, you know, because commercial itself, the competition is stiff lah. A lot of underhand things will happen. So before the creditor's petition will be even heard by the court, there will be one requirement here. Registrar certificate pursuant to Rule 32 companies winding up rule. Remember that, Okay. You see, the winding up petition, first is that must be duly gazette and advertised. Gazette means if you Google online, there is one Federal Gazette, you know. Federal Gazette is like something that announced to public and everyone has access. The lawyer need to pay the Federal Gazette to publish that creditor petition. Okay, the company winding up petition. Sorry. Okay, and then second second thing is that the winding up petition must be advertised. Advertisement means you have to publish in two local newspaper. But last 2 years, if I'm not wrong, last 2 years, these rules have been slightly loosened. You can actually publish in SSM. SSM, there's a one portal, you have to pay 5 or 10 ringgit. That one I'm not so sure. Usually my clerk will pay. Even more cheaper version as compared to newspaper. Newspaper, you publish this sort of advertisement, sometimes can cost you 500 ringgit per advertisement, and this will be more costly. So nowadays, SSM also wanted to have their profit. It is allowed, you know, we can publish in SSM. Okay, then B, you need to have affidavit verifying the statement, and also affidavit of service of petition had been duly filed also. Okay, and then you have to usually is that our affidavit will say lah, the petition is not nominating its own liquidator, and therefore no consent of any liquidator is required. Okay, and other compliances. Okay, wait, let me just erase all of them to proceed. Okay, so this is one of the example here, affidavit verifying petition. Okay, so usually this is executed by the creditors director, the petitioner director. That means the person, the boss lah, our boss lah, will do this affidavit. Okay, this is pursuant to Rule 26 companies winding up rule. Okay, take that as an example. And then subsequently, you have to serve to three parties. Usually, who will serve this affidavit And also the petition too is that we have to serve to, of course, the company registered address, their company secretary, and also SSM, uh, company secretary or their registered address lah. And also we have to take into the consideration to serve to apa nama the DGI, the Department of Insolvency. Okay, so this is the affidavit example here. Okay, and this is the advertisement requirement. This is the one that I told you lah, the Federal Gazette. Um, like this, it is come into this format, and you have to pay for it. Okay, you have to pay for it. And also two local newspaper. Like I've told you earlier, newspaper nowadays you can substitute with a cheaper option, SSM punya portal website. Okay, so these are the requirement before you can get the registrar punya certificate. So this is the example here. I'm sure many of you don't read newspaper lah, but last time used to have this. Even bankruptcy, all that, like evading service, that they still use it. And the worst part is that now, if you have any disciplinary order by the bar council, they also publish here, you know. Oh, you. So, not something that is good to know lah. Okay, on our end. Anyway, if this thing proceed to hearing, because every petition is not an ex parte hearing, is inter parte. Two parties need to attend. Okay, the applicant, the one, the creditor need to attend, the petition need to attend, and also the respondent, the company that owe money, also need to attend. Okay, so notice of intention to appeal is that, do you at your end, because usually we go for winding up proceeding and you have other potential parties that may want to join this hearing. For example, the other creditors that you know of. If let's say, for example, during construction, we used to represent multiple subcontractor. The main con Sendirian Berhad is unable to pay the debts for our subcon. So there are several parties that you cannot combine all the debts and make it one not this statutory notice, you know. So you know that they are interested party. Probably they wanted to attend this hearing also. Okay, but usually they don't attend lah. Trust me, nobody will attend lah. Okay, and this is the court order. If your petition after the open court hearing, usually the court won't hear also if that the the debtor company did not send any representative to attend. We'll get our PSP lah. Okay, perintah seperti dimohon. Quite easy lah, not so hard, by the way, quite easy. Okay, so what are the key changes to the prescribed amount on company winding up? Okay, last time COVID time, they give some extension, you know, because that time a lot of company have money rolling cash flow type problem because no business and MCO isn't it? So lockdown, no business, they extend 6 months. But after that, now the threshold to file creditors winding up petition will be if you owe more than 50,000 and you have got that statutory notice pursuant to section 4466, and 21 days after the service you never pay, you ignore it, then people can file creditors winding up against company. Okay, then you will have problems. Okay, am I clear so far before I discuss Q&A so that you all can understand the what we call the facts better? Am I clear? Must know how to make a company bankrupt, wind up and also make a person bankrupt. Then only you can learn how to play the tricks behind it. If you do know that procedure, a bit difficult to, how to say, to understand the question also. It looks all blank to you. Okay. So this is a sub 2025 question. You see, Ranbir is an in-house legal counsel for Serba Wangi Berhad, okay, a company with diversified business. He then found out one of his subsidiaries, Dynamica Sendirian Berhad, had issued one notice of demand, you see, against Mahakaya, demanding payment how much? 18.23 million ringgit. Okay, with the endorsement that failure to comply will result in winding up procedure. So from here, you know that this is statutory notice already. Okay, this is statutory notice. Okay, that judgment, you see, the judgment here was obtained 5 years ago. In fact, judgment is not required to wind up a company. I repeat myself quite a number of times. Okay, and it was recorded against Kaya Maha as principal debtor, plus two directors of the company as sureties. Okay, sureties means guarantor lah. That means if the company cannot pay the money, you can go after the guarantor. And here, because this is company commercial transaction, this is not by virtue of social guarantor. It's not social guarantor. You are social guarantor if you loan the money. Let's say I get a 1 million loan lah. Okay. Social guarantor means if let's say the loan is used for what? For house loan, hire purchase, for my study fund, personal use. That one's social guarantor. If commercial world, you are acting as a guarantor for a company, for investment to make more money, this is not social guarantor. You will be liable for that debt if any default happen. Okay. And what happened is like the sum demanded include interest for a period of over 6 years. You see or not? Over 6 years. So no solicitor's firm was involved in the service of that notice of demand. Okay, see, is it required for a lawyer to issue statutory notice or not? The straight answer is no, because you don't need yet. You don't need yet. Okay, but subsequently, winding up petition, you will need somebody to act for you lah, because you are Sendirian Berhad. You cannot go to court in person. You must engage lawyer. Okay, so what happened is that the winding up petition was subsequently presented on 22nd day. Follow the date. You see, the word is like this. The date of notice of demand. Okay, just now I have repeated myself the 21 days rule. The 21 days rule, how it comes is not from the date when we issue this notice of demand or statutory notice, but rather this is the date the service occur. For example, I can date it, today is what date? 21st June 2026. My statutory notice date 21st June. But the company that suppose I issue that, okay, Asia Group Biopharma Sdn Berhad, receive it 30th of June. So the date actually calculate from 30th June plus 21 days, not from the date of our own date. Remember that one. What happened next from the fact is Mr. Mustar, the GM director of Sebawangi, has informed Ranbir that Kaya Maha is still a rich company, lah, asset rich. So bankruptcy proceeding against sureties were defeated for the reason that the petition were not properly executed, that the petitions were filed in KL and were attested by lawyers in Kota Kinabalu. Okay, so this is one of the I have just checked, like a day before lah. Okay, the law said that um we are like, for example, I'm from Johor, okay, and some of you mostly will come from Selangor. We are only registered as advocate and solicitor of High Court of Malaya, Malaya. We are only allowed to practice in Peninsular region and Wilayah Persekutuan. That will include Kuala Lumpur, Putrajaya, and Labuan. We are not allowed to practice as advocate and solicitor for Sabah and Sarawak. Okay, different law, remember. So a lawyer in Kota Kinabalu cannot attest that particular petition. Okay, the creditor's petition cannot be attested by somebody from Borneo. You get me? We are Malaya, that part is Borneo, Okay, so the story continued there. Wait, next page. This first. Okay, so Mr. Mustar further stressed that the intended winding up proceeding must comply strictly with the relevant procedures as the recovery of the judgment sum is crucial for Sebawangi's Berhad survivability. That means to say they need the money badly now lah. Okay, so Ranbir, as the in-house counsel, need to advise his boss lah on how to make a person bankrupt and also how to make a company wound up. Okay, so now the first question is that whether the inclusion of claim for interest more than 6 years will make that statutory demand bad in law. Okay, we'll come to the first question first. Okay, so what he need to resolve is that Dynamica here is the judgment creditor. We all know that they got judgment 18.23 million that was recorded about 5 years ago. Okay. And then who is owing the money here? Ini Kaya Maha Senjaran Berhad. And there is also involvement of two directors apa nama? As the sureties, as the guarantor here. Okay. So in order to answer our question, okay, we have to recall back what is the legal gateway in order to make a company wound up. Okay, you see, the first threshold is what I have told you is the company unable to pay the debt. Okay, section, this one, 4651E. And then subsequently, you issue this statutory notice, but no response. After 21 days, the Mahakaya company received that statutory demand. Okay, so this will be deemed as inability to pay. Okay, you must also highlight one thing here. Asset rich is not decisive, We don't care whether this company has a lot of land, a lot of property. You see, wow, their company is so big, listed company, all that is not a concern. Okay. The solvency, commercial insolvency, that is the ability to pay the debts. If they fail, that means to say they fulfill these two component. Okay. Be have that in mind, please. Have that in mind. Okay. Because the question will will be evolving around these typical issues. Okay. If the interest exceeding 6 years can still claim or not? Okay. The answer is actually section 6. Actually, the answer is no. Why I write yes? Ayo. Here, the answer is no, Wait. Because Section 6, Sub Rule 3 Limitation Act 1953. Okay, clearly by the case of Wang Sini said, if because the question asks you, you see, interest exceeding 6 years can be included in the statutory demand or not. Okay, there's a bit of confusion here is that the judgment is still within 5 years. I don't know why the examiner asks you to calculate the interest for 6 years. So I assume this is an advice question. Okay, if after 6 years, for you to enforce a judgment, I'm sure you all know lah, by rules of it's a limitation act here, section 6 sub rule 3 said that if you want to enforce a judgment, your maximum lifespan is 12 years. You know that, right? Okay, 12 years. But after 6 years, you want to enforce that judgment, you should get the permission from the court, leave of court. Here, specifically, Section 6, Sub Rule 3, Limitation Act said that you can only claim judgment for 6 years interest. More than 6 years, the interest, sorry, cannot be calculated. Okay, very important. You refer to Wang Sini punya case and also Perwira Afin Bank against Tan Ai case. This one. Okay. The answer is no. No. I made a correction. It's no. You cannot claim interest. Okay. Where is it? Okay. Second question, Ranbir is to ask to comment on this. Can the petition be presented on second day after date of statutory notice? The question is quite clear. Okay. The date is calculated from the day of service. It has nothing to do with the date on the letter itself. So the clear answer is no. Okay, petition can only be served on day 22 based on the actual date of service. So this one you have to cross refer to section 466 sub rule 1 sub rule A of Companies Act 2016. Okay, quite simple, quite simple. These two questions very in fact quite simple lah. Quite simple. Okay. Then the third question is actually ask you how to make companies wind up. Okay, very simple if you follow my flow. Okay, first give that notice first at the registered office. Okay, this one SSM you can check. Tunggu 21 hari. But here the notice of demand must more than 50K lah. Otherwise no need to send lah. No need to send. Okay. Present petition. Follow rule 23 companies winding up rules. Okay. within 6 months of notice. This is pursuant to section 466 sub rule 2. And then subsequently, if this OA official assigner, last time we call liquidator lah. Liquidator is required, then probably you need to deposit 3,000 ringgit for administrative fee. But usually we don't bother. We'll say that you don't need any official receiver or official assigner. Okay. And you must put the affidavit verifying petition, just like the cost paper I showed to you, in Form 7 within 4 days under Rule 16. And then you have to serve plus, apa nama? You have to serve plus advertise. Okay. Okay. After that, you get the certificate by the registrar certificate pursuant to Rule 32. Okay. Then they'll plan for hearing. If there is any opposition, the the company, the debtor company, the respondent will need to file affidavit in reply. Okay. The hearing will be in open court. If order made compliant with Rule 34, the company will deem to have wound up. Okay. Usually you go with what? How to tackle those typical exam question is you check for the defects. Here, the statutory demand serve the date not compliance, or here, the substance part, the procedure also for the service is not good. The cost paper, the advertisement was not there. So this is how you oppose the winding up proceeding. Okay. There's one issue is that this Kaya Raya is asset rich, but like we have said to you many times, commercially insolvent is really the issue here. We don't look at the balance sheets assets. Remember that. Nothing to do with us. Okay. So number D is we are asked to comment because the previous bankruptcy petition, creditors petition, I suppose that's supposed to be signed by the KL lawyer. Then they went and asked one Kota Kinabalu lawyer to sign. This will be rejected. Rejected because the lawyers acting there, they can only go for High Court of Kota Kinabalu and Kuching. These two only. Okay, they are different. Sabah Sarawak punya. So petition filed in KL supposed must be signed by advocate and solicitor from High Court of Malaya. That means us lah. Okay. So this is about the proper attestation. Okay. You can refer to case of Lee Kok Kong here. And authority to execute, companies also need to act through an official agent or this officer. Okay. And then should give the corporate seal to make this petition authorities valid. Okay. In doing the affidavit, this one. Okay. So I think this question not so tough, to be very honest, not so tough. Am I making you sleepy or am I making you more problematic at this moment of time? You'll go through another 2 questions, then you can have a good rest lah. So far, are we good? We don't have a lot of students joining. Yeah, probably you can tell me your feedback and all. So far, okay? as compared to civil procedure evidence, I think this is a bit dull lah. Never mind, you come for my evidence and criminal, I will give you an excellent because you'll be having hands-on one. This one, uh, yeah lah. Is this practical? Just start to learn background. Yes, it is quite practical. In fact, I saw only 30 pages for the whole syllabus for IA and also company winding up. So you still have time to learn, eh? And very easy, you know. Trust me, very easy. Uh, you need to memorize the rules, the rules, service rules. You do know so much also, never mind. So long you know the 21 days, the what we call the act of bankruptcy, the bankruptcy notice. You revise my previous slide, I think you can answer lah. Okay, we'll go to our second question. Mr. James here, he is a very successful businessman. He owns so many companies. They're all doing very well. So back in 2017, he set up a new company, Malaysian Vegetable Sendirian Berhad. And that company supplies vegetables to supermarket across the country. James owns 95% of the shares of the company and he is managing director. The other shareholder and director is his son, Mr. Dumbo. Okay. James had paid up 3 million cash into the company as working capital. That means the company rolling fund is based on 30, this 3 million, but still not enough. He borrowed a further 3 million from lender bank, the bank lah. Okay, and the bank agreed to let him repay 100,000 ringgit per month for 36 months. Okay, so the business has been excellent, and then the company had received order and deposits from 400 supermarkets across the country. So as you can see, how good is the business is that the current net value of the company worth up to 10 million ringgit. And further, there are fixed deposit exceeding 3 million ringgit from the last year profit alone. And the company also expect, you see, another 4 million after tax profit to be generated this year. So demand for fresh vegetables is growing. James need to find new vegetable suppliers. So he's probably going to Vietnam, Cambodia, all sort of part of Asia to get long-term supplies. Okay. So in his last 4 months away in Vietnam, he had been looking for new Vietnamese vegetable suppliers. Before James went away, he actually entrusted this company to the hand of his son. Apparently, Mr. Dumbo here, like the name would have suggested, not a very clever person. What he did is he disobeyed James' instruction and he had made no repayment to the bank. Okay, so the bank manager tried many times to communicate with James and also Dumbo. Dumbo too busy in partying not to answer at the bank. The bank had served the company the demand under section 4651E. That is inability to pay the debt statutory notice. And subsequent paragraphs show that the notice of that service is complete because it's served at the registered office, and the notice demand us to repay all outstanding sum within 21 days. The notice say that if the company did not pay 1.8 million ringgit within 21 days after the notice of demand, the bank will actually file a winding up petition against the company. So the company staff have been waiting for Dumbo to give them instruction, but Dumbo is busy organizing dance parties. So Dumbo will not even answer the phone. So Dumbo did nothing to pay the debt. Okay. So after serving the notice under section 465, subrule 1, subrule E, so the bank filed winding up petition because they are angry already angry and cannot get money. So James returned last week from Vietnam. To his horror, he realized how what is the foolish thing done by Dumbo. He realized what happened and he immediately rushed to the bank with a check amounting to 1.8 million ringgit and offered to the bank manager. So the bank manager said the bank is quite unhappy with the company's lackadaisical attitude. The matter is already in the hands of solicitor. My instructions are to continue with the petition to wind up the company. I'm sorry, James, business is business. The winding up petitions comes up for hearing in a month. The board, although James, seek for your expertise, how you want to solve for James here. Okay. So who are the parties? Uh, First, we have Money, Malaysian Vegetables Sdn Bhd. That is actually the creditor company. We are representing them, right? And we have a lender bank. Okay, initially loan about 3 million, but partially paid. Now I suppose the amount will be 1.8 million based on our statutory outstanding outstanding sum lah. I would say the statutory demand here is no problem because the service everything is on time and the amount was what we call is stated lah, is stated. No doubt I don't see any statement of account, but I assume they are. And subsequently, our profile is like that. Okay, we have money. Now we want to settle. 1 cent also I don't want to owe to the lender company. How can we go about that? Okay, so where are we? Based on this flow chart, this is all about issuing 21 days statutory notice. So we are at the hearing of winding up petition already, Okay? They are about to go winding up order. So what we need to do is to see. We have to refer back to the answer given by the laws. Okay, definitely 456, 466, all these you cannot challenge. You have to agree with them. Okay, because all this have been done. This one, no need much discussion. The only thing we can do is that there is no statutory requirement for the judgment must be obtained. Okay, so judgment actually no need to be obtained in order to issue a statutory notice. Therefore, you also dismiss this ground. There is no ground to the judgment itself is not a prerequisite for you to issue a statutory demand. So that one also we can dismiss it. And liquidated sum in section 466. In the notice, mention all outstanding sum and all 1.8 million. Despite there is no requirement of proper format 466, okay. However, liquidated sum must be clearly stated according to Ng Ah Kwai against Tan Thai Kit Enterprise Sdn Bhd. Such ambiguity and uncertainty in the bad debt could be a ground for opposing, because your number itself is not quantified. Sometimes it happens. So if you do not have a quantified amount, certainly the opposing party will say that this action has been prejudicing the respondent because he does not know how much debt he has to meet. Okay, that will be your technical problem. And in furtherance, the fact is silent about the publications in two local newspaper and also the um, Warta, the Federal Gazette. Okay, so the bank did not advertise all that. Should it not done, they cannot get the certificate of compliance from the registrar. You must understand, you have to get advertisement, you have to get deposit if you need any official assigner to in charge of that company asset distribution anything, you need to pay 3,000. Then subsequently you need this affidavit verifying the facts. Okay, then only the registrar will grant you a certificate, the registrar certificate of winding up petition. After you get this, then you can arrange for creditor petition hearing in the court. Okay, not so easy. Now we have to come to the issue of inability to clear the debt. The company is advised that the inability to pay a debt is that of commercial insolvency. Use this classic case, Malayan Plant against Moscow Norani Bank. Okay, a company can be wealthy and insolvent at the same time. So, in commercially insolvent means no current asset available to meet the current liability. This is how. So relating to the scenario given, it was obvious that the company is commercially solvent, as true manager James was able to pay 1.8 million ringgit as a lump sum. Now you have to help this company, Malaysian Vegetables Sendirian Berhad. Okay, creditors' petition have been made up against you already. The service is regular. Nothing is at fault here. Now you have to go for the merit of the case. All right? By showing the merit of the case, how you want to defeat it. Okay, you have to tell the court, say that, look, I want to pay. I want to pay. Okay. What normally you need to do is to file affidavit in reply, attach the proof of 1.8 ringgit payment, then you can stop the whole proceeding. Especially you put the proof of transaction. Like they don't want to receive, they don't want to bank, you put their name and then you slip inside their ATM lah. Then there will be a proof of debt, clearance of the debt. If there is no debt, the creditor's winding up petition will be stopped by the court, will be withdrawn by the court. Okay. So now the problem is that the company has money to pay. So this thing should be easily win. Okay, easily win. But I also wanted to discuss there is element of foul play here lah, because you see when James approached the manager, they claim the lackadaisical attitude and all that. All that is actually a form of malicious prosecution. Okay. So company should file affidavit jawapan lah, 7 days before the hearing and serve to the petitioners, and their affidavit reply can be filed by the applicant within 3 days from the date of service of affidavit in opposition. Okay. As simple as that. So other than that, take for example, extra knowledge lah. If you want to stop a company from urgently proceeding into company's creditors winding up, because once company creditors winding up, a little bit difficult, All the assets, everything will be surrendered to the hands of usually DGI lah. Malaysia they use DGI. They don't use official adjudicator and also official assigner anymore. The cheap one we go for DGI. DGI will have full say how to distribute the assets of the company. Let's say there is a case of malicious prosecution. And enemy want to sabotage you lah. They purposely wanted to wind up your company. You can find this Fortuna injunction under Order 29 and referring to the case of Mobicon Sendirian Berhad against Imis Communication to stop the winding up proceeding. Okay? To maintain everything status quo until the full realization of payment has been made. Okay? So far, am I clear? Am I clear? Or is it a very difficult subject? Not really, like. Is it tough or how? How many pages left? Okay, we still have a bit to go. Okay. We'll go through a few questions more, then probably we can wrap our session. Okay. So far, any question or anything that you don't understand at all? It's about the rules, how you overcome the rules on it. They won't ask you too complicated things. So your requirement is only help people to bankrupt, help them not to bankrupt, help a company to bankrupt one company, and help one company not to get winding up. So only 4 scenarios. You are using almost the same rules. So I think for those who are interested to do insolvency and winding up, it may not be a good, it is a wise choice, I would say. Wise choice. Okay. So we go to, okay, 2019 sub Q. Ahmad is a chef here. He runs 20 chain of Balinese restaurant across Klang Valley under the name Bali Istirahat Sendirian Berhad. So the restaurant is exceedingly successful. One day, one patrons came to see Ahmad. They are from Perak. They tell him how good is the food and beg him to open Bali Istirahat branch in Perak. So looks like they wanted to expand their business to Ipoh lah. So the companies open 5 new restaurants in Ipoh alone. The company need borrow some money, isn't it? Okay, need money for operation and expenditure. The company borrow 100,000 ringgit from Bangkok. A security for the loan, Ahmad signed a personal guarantee. See, Ahmad is a personal guarantee. If the company ever default, the guarantor require Ahmad to pay the bank all outstanding sum at the time of default. Okay. So as he lived in KL, Ahmad was compelled to travel to Ipoh at least twice a week. In this way, he ensured Perak business had his personal touch. Okay. Last year, Ahmad fell sick. He no longer be able to travel to Ipoh because of his absence. Business also dropped. The company could not keep up the repayment to the bank. If default the monthly installment, the bank sent letter of demand and demand that he as guarantor to pay the outstanding amount. In the demand, bank solicitor stated that sum of 45,000 was actually outstanding from the company. Ahmad was so ill, pay no attention to the demand. The bank sued Ahmad as a guarantor. It obtained a judgment against Ahmad. A judgment states that Ahmad shall pay judgment of 45,000 ringgit to Banco, interest at the rate of 5% per annum on judgment sum until full satisfaction and the legal costs payable to the bank are to be assessed. So, and that was December 2013. Ahmad did not pay any payment further. So, 5th January 2019, bank served bankruptcy notice. Bankruptcy notice asked Ahmad to pay Banco Berhad a sum of 45,000 plus cost plus interest 5% per annum. Again, Ahmad was ill, he did nothing. So 5th November 2019, bank solicitor served Ahmad a credition petition. Okay, so the petition is dated the day before 4th of November 2019. The creditor's petition state Ahmad is justly and truly indebted to Banco Berhad the sum of 45,000 ringgit plus cost and interest at 5% per annum and continue. So Ahmad had come to see you and he's asking for a few advice here. Whether bankruptcy notice is valid and on what grounds Ahmad can challenge creditor's petition and what procedure do you intend to do to oppose creditor petition? Okay, when we look at this, we summarize as a very short form. So this is what is happening here. What is happening here? Okay. The timeline. Okay, this one I don't need to repeat myself. Okay. So how do you answer this question is that the facts suggested that Banco had commenced legal proceeding against Ahmad on the ground pursuant to Section 3, Subrule 1, Subrule I Insolvency Act to challenge the validity of the bankruptcy notice. Ahmad is advised to do the following. Okay, Ahmad must prove he's the social guarantor, but a bit tough here lah. You see, Ahmad was other guarantor because he made personal guarantee for Bali Isti Berhad to secure the loan, Okay, so pursuant to Section 5, Subrule 3, Subrule B Insolvency Act, bank must obtain leave of court prior to commence bankruptcy action against Ahmad. This is our protection here. Even though we are the guarantor, we are the last that the bank can come to us. We guarantor because, guarantor is the last forte. If the company is seriously gone in totality, everything sold lah, sudah tak ada lah apa-apa. One pen also don't have in their office. Then there's time to go against us. But here the fact is not clear whether Banco had exhausted all the mode of execution against the company, okay, the Bali Isti Rehan, okay. So the bankruptcy notice as such will be null and void for this ground. By right, listen to me carefully. if you have a debt here against a company, X company, and it is backed by two director. It's backed by two director. But so ugly. Okay. Okay, two director. You can only sue X Sendirian Berhad Gao first. That means until it couldn't produce 1 cent, then only you can come after harassing the guarantor. Okay? Get it, huh? Uh. Okay. Mm, wait, where is it? So 7 days for Ahmad to settle the date. Okay. 7 days itself is not enough to settle a date. So this is not the day that allow in our bankruptcy notice. So there is what we call infringement of section 3 subrule 1 subrule I of Insolvency Act. Therefore, the whole this bankruptcy notice is actually invalid. Invalid. Okay, you must remember that. Other than that, what will be the issues that you can actually explore with that bankruptcy notice? Instead of total amount, they put like this. You see, judgment sum 45,000, interest rate legal to be assessed. This is not giving you a exact figure like 70,000. No, they ask you to calculate yourself. This is technical failure. Exact sum must be calculated based on the case of Fauzia Osman against MBBM. So if you don't calculate according to the law, section 3, subrule 1, subrule I, Insolvency Act, if you do not quantify up to the date when you have issued the bankruptcy notice, this bankruptcy notice itself is invalid. So, in the event of invalidity, you will have to file it again. Okay, you have to file it again. It does not defeat the whole bankruptcy proceeding, but its only thing is that the one job you have to do it twice long. Okay. So to challenge the creditor petitors, okay, because we challenge the irregularity of bankruptcy notice, now we go to the second part, challenging as for the creditor's petition. Okay, so we can challenge the CP will be null and void. Okay, pursuant to section 5/7 1A. Okay. And there will be non-compliance on this bank pursuant to section 3B 4 and 6 19 uh 60 67. Okay, let us check with what are the rules about. Give me a bit time. Let me open up Insolvency Act. Section Ooh. Fine, fine, fine. Now, here, can you see my slide? Here, here say where the conditions which accreditors may petition. Okay, 50,000 is the one, the what we call one threshold law. Okay, and liquidated sum. Okay, that one is agreeable. 6 months before presentation. Okay, now we are contending on section 53B. 53B, that means to say they don't have leave from the court to go against him. Reason is because the guarantor is sometimes a boss like me now, for example, I can have several companies. I can have 4, 5 companies, some new company especially, but I need money. My face in the bank will get me money, but provided I sign letter of guarantee. You get me? My reputation, all that, they will take into consideration. Otherwise, new company cannot get. But for them to get judgment against me and wanted to enforce me against me, they have to first sue the company until it is totally no asset wound up. Then only they can go after me. They go after me is to commence bankruptcy proceeding. So this part they never did. Okay, 5-4 and 5-6 also they never did. See what is 5-4 and 5-6. See, because they have not exhaust any mode of execution. Okay, they have not exhaust any mode of execution. See, and where petition is presented, you can present in the petition particulars. Okay, so we caught them for the technicality problem. Okay, we are back to our slides. This one. Okay, service of creditor petition more than 6 months. As we have corrected, read after the statutory notice, the bankruptcy notice was served by Ahmad, the BN, the BN served on Ahmad, but Ahmad failed to respond by taking any remedial, okay, within 7 days. Okay, so the act of bankruptcy was deemed to be committed on when? On 8th of January 2019. So accordingly, when the act of bankruptcy committed, the creditors will need to issue creditors petition 6 months from the date of act of bankruptcy committed. But in this case, Ahmad was served with CP creditors petition from November 1st, 2029. So if we calculate the 8th of commitment of act of bankruptcy was actually done on 1st of 8th of January, and this is done on the 1st of November. Clearly, the 6-month validity period of creditors petitions has been lapsed, Okay, so the whole CP is invalid. They have to do it again. And a few points here on the fact the debt is only 45,000 plus everything, and they don't quantify some more. Not quantify their debt lah. Okay, it is lower than the prescribed 100,000 value pursuant to section 5 sub-rule 1 sub-rule A. Therefore, the whole bankruptcy proceeding, even the CP itself, is defective. And worse is that you do not quantify to bring to the attention of the court how much you own is very important, and it must come in an exact figure. You cannot write something like 45,000 plus interest continuing plus cost. Cannot. This is not a quantifiable sum. And pursuant to section 5 sub-rule 1 sub-rule B Insolvency Act, CP will be deemed defective. Okay? So because of you have a few technical merits here, Ahmad can do is to set aside CP by doing a summon in chambers. Summon in chambers is just like our our notice of application. It's just different name. Okay? Supported by affidavit using Rule 17 insolvency rules to oppose it. Okay? As far as is it concerned, bankruptcy proceeding and also creditors winding up proceeding, if you read your Schedule C, I think Schedule C, rules of court, okay, they do not have govern that part one. One of it is bankruptcy, winding up. The third well-known one is what, they don't kacau. Matrimonial proceeding. The divorce proceeding, they don't involve. Rules of court. So next queue. Okay. We'll finish this queue and then everybody can pack their bag and rest for a while about what I'm going to say. Okay, XYZ here had a loan of 2.5 million, of course, from a bank, ABC Bank. What they want to do, they want to use the money to purchase the land to build new factory. So XYZ principal business was to build vehicle components for export to Southeast Asian country. So as security for the loan, XYZ create a charge under National Land Code over the said piece of land in favor of ABC Bank. So charge itself will remain to be some sort of you have some registrable interest. ABC Bank have registrable interest in that particular land already. Now you see, some more, they did an irrevocable power of attorney also executed by XYZ Sendirian Berhad in favor of ABC. So this power of attorney seems is what? Is one form of surat wakil mentadbir, They usually launch in High Court, signed pursuant to 1948 Power of Attorney Act, PAA 1948. Very old act, only 3-4 pages, very easy to understand. They have created such. Some is revocable, some is not irrevocable. Okay, what this POA or PA grant the bank function is that the bank can anytime represent XYZ to go to a lawyer and sign that land and transfer to new buyer. They can do so. Okay, try to understand it. And at the same time, Zack and N, who were the directors of XYZ Sendirian Berhad, executed a joint and several guarantee. Again, we are looking at non-social guarantor issue here. Okay, to guarantee the repay of the sale loan lah. So XYZ defaulted payment 2.5 million ringgit, resulting in ABC filed a civil suit in Ipoh High Court and got judgment, summary judgment. Here is only summary judgment, 1.2 million against XYZ as well as Z and N. Okay, XYZ, Z and N then file an appeal to the decisions of High Court in allowing ABC's summary judgment. Okay, so that summary judgment, because it is an interlocutory judgment, something fast lah. Maybe the party is giving some sham defense, so they file a summary judgment. Okay, but that judgment was not undergone full trial. Ini bukan satu penghakiman penuh. Jadi apa nama XYZ dengan pengarahnya memfailkan rayuan ke itu Mahkamah Rayuan Putrajaya. Okay, so this judgment is not a final judgment. Remember, not a final judgment. Okay, therefore ABC Bank, okay, what do they do? Based on summary judgment, they issue statutory demand on 1st December 2019 pursuant Section 466, and ABC only demand XYZ to pay 1.2 million without taking consideration of the interest and owning as 1st December 2019. XYZ failed to respond to the said notice despite the same being served in accordance to the provisions of Companies Act. That means to say person service had occurred. So ABC then initiated winding up proceeding against XYZ on 1st May 2020. Is there any 6-month lapse? No, not yet. Not yet. December, January, February, April. Yeah, no, not yet. So, and did not file any affidavit in the opposed and trial. Okay, the morning of the hearing. So XYZ informed the court that the affidavit in position to wind up XYZ was filed and served to ABC's bank's solicitor. The winding up court allowed the objection ABC's bank solicitor and struck off XYZ's affidavit in opposition and therefore proceed to wind up XYZ Sendirian Berhad. So after XYZ was wound up, ABC filed a foreclosure proceeding. To foreclose on the said piece of land was charged at ABC Bank without leave of court. Alright, as well as bankruptcy proceeding against both Z and N. This question a bit hard because winding up proceeding, the order had been granted, now is a few issue here. Okay, XYZ wish to appeal to the winding up order. In your opinion, advise ABC on whether XYZ Sendirian Berhad will succeed in their application. Okay, we look at the story flow so that we can pick up our mind. That is, you see, initial loan 2.5, XYZ first party charge over the land and also granted power of attorney. Z and N will be the guarantor. Then subsequently never pay. ABC file a summary judgment 1.5 million plus interest against XYZ Sendirian Berhad. Z and N, all three defendants actually appeal with that summary judgment, and statutory notice comes in when 1st of December 2019 for 1.2 million. Okay, still no response. Okay. And then winding up proceeding far, the current status is they want to auction that land lah. Okay, so what is the first question? Okay, whether they can succeed or not. Okay, so ABC had commenced the winding up proceeding on the ground that XYZ was unable to pay its debt pursuant to Section 4651E Companies Act. So the definition is clear, lor. They cannot pay, and you can use a Malayan plant against Moscow Noroni Bank to say this is commercial insolvency. And apparently XYZ had not responded the statutory notice after the service, the receipt of service, 21 days, then it was still proper, So the statutory notice part of XYZ Sendirian Berhad has no problem at all. Okay? Has no problem at all. Okay. That means the bank did a good job lah. Okay. Here I put 10,000 is because that time it may not be 50,000, That time at the end of the incident. Wait, we are looking at December 2019. So that time, if I'm not wrong, it's still 10,000. But don't worry about this figure. We are going to look at 50,000 onwards. Okay, this one you don't know, it's still okay. So the debt is dispute on substantial grounds or abuse of process. Since XYZ had appealed the decision to the High Court allowing ABC summary judgment, the said judgment is not considered final. But you must remember, this is against company. If it is against individual, you must have a final judgment. But here, there is no requirement for the judgment to be final, Even if there is outstanding, you can prove the statement of account, then you can issue statutory notice against a company. However, anything is arguable. Okay, XYZ may need to prove good faith to dispute on the substantial ground on the debt's amount. Okay, therefore, disputable debt could amount to a good ground of appeal. Okay, probably you can say something like, you see, instead of they get summary judgment 1.2 million with interest, with interest, Now it is with, is there anything ongoing between the parties? That means to say you varied from the final judgment. Final judgment give you 1.2 million plus interest. But why you are not calculating the interest with him? So this will be one of the ground to show that the sum is not finalized yet. Disputable lah, it's still disputable debt lah. Okay, and unlike bankruptcy notice, you don't need to quantify the interest. Okay, it will not invalid the statutory demand. This one also you need to advise ABC. Okay, so ABC in fact here is doing a good job lah because we are advising him. And on the fact about the service and technical irregularity of the notice, on the fact it was told that the notice of 12 days were duly compliant by ABC Bank. So therefore, there is no appeal on that ground. Okay. So, but now remember we need to get a registrar certificate pursuant to Rule 32. For you to get that, you need to give affidavit verifying the facts. You have to give Federal Gazette plus two newspaper. This may not have this may not have done it lah. This may not have done it because the facts are silent. But however, failure to advertise is still not a fatality. It is still curable under Rule 193 and Rule 194. That means to say you can publish the newspaper later. Okay. And Rule 30, we talk about the opposing counsel, SYZ counsel, suddenly on the day of hearing, they wanted to argue with you. So what happened? So Rule 30 provides that XYZ may propose the petition and file affidavit in opposition 7 days before the hearing. So this is based on APMG Management Sendirian Berhad. Okay, the time frame is a mandatory requirement, Therefore, the court decision to strike this XYZ's affidavit in position was correct, So XYZ could not rely on this ground to appeal. Okay, and the next question invite us to check whether we need any permission since we have the charge and also since we have the power of attorney. We can go auction, but a foreclosure proceeding is like an auction for company lah to lelong barang dia kot tanah. Okay, so we must cross refer section 471 Companies Act. When winding up had been ordered by the court, the liquidator had been appointed. Leave of court must be obtained by ABC Bank before proceed to foreclosure. Hence, ABC Bank had not followed Section 471 Companies Act. Okay, and we have case of Carlson White, Malaysia, said that proper remedy against a winding up order is to exhaust the provision of Section 470 and or 471 Companies Act to stay the winding up order rather than appealing it. Only a failure to apply a stay order, a company can appeal against the winding up order. Therefore, XYZ needs to apply for a stay winding up order before filing its appeal. But as an overall conclusion, XYZ will be less likely to be successful in his appeal. Okay? Can understand so far? And this is the last question that we want to discuss. Z and N also apply to set aside bankruptcy notice filed by ABC. Okay, advise ABC based on Section 5 to Section 57 of Insolvency Act and decided case Z and N can succeed in their application or not. Here, this is very much to do with the other guarantor meaning. Okay, so N and Z are so-called other guarantor pursuant to Section 5, Subrule 3, Subrule B of Insolvency Act. In order to commence any bankruptcy action against them, the bank must exhaust all remedy against the XYZ company first. Take, for example, sell his land, read and Caesar, any nice chandelier, light, aircon, all sys. Even garnish the account, see Maybank got money or not, take it first. If all being exhausted, then only they can switch and turn their gun to guarantor, So this is how it plays. Okay. On the fact, ABC Bank did not obtain the leave of court. Therefore, the error must be rectify. And ABC Bank is advised to proceed the foreclosure of the land and exhaust all mode of execution enforcement to recover debt owned by him by XYZ, pursuant to Section 5, Sub-Rule 4 Insolvency Act. The said mode of execution and enforcement include, like I've told you, seizure and sale. JDS we hardly do lah. Judgment, debtor summon, garnishee proceeding, winding up proceeding against XYZ Sendirian Berhad pursuant Section 5 Sub-Rule 6 Insolvency Act. ABC Bank on the fact had not yet done the foreclosure proceeding before commencing bankruptcy proceeding against N and Z. So in submission, since we are to advise ABC, isn't it? It will be advisable ABC to compliant all the requirement aforesaid. Otherwise, the court may not allow N and Z to get bankrupt easily. Okay? The creditor's petition will be dismissed. Referring to Hong Leong Bank against Ong Mun Huat. Okay? I think what I'll do is I will stop here because most of the question is repetitive, I have done some, actually another 2 or 3. I will upload to you and see how you can tackle the question. But usually you have to learn how to make a person bankrupt first. What are the criteria and how to make a company wind up? And then you have to know section 465 and section 466. What does it mean by commercial insolvency? Then probably you can do a good job for this paper lah. If I were you, I would choose to do lah, because when I look at the syllabus, let me share with you with the syllabus. It's quite simple, you just read this field. Here is the syllabus. Part 2, insolvency and winding up. A few pages only, What is the meaning of a debtor? Okay, who can be sued bankrupt? A foreigner can or not? Infant can or not? Married woman can or not? Person of unsound mind, MP, diplomat, can or not? Guarantor. This one is very important. See? Definition of social guarantor. But if you guarantee on behalf of business, you are not a social guarantor, So these are the things. Estate. So what does it mean by unsecured creditor? That means they don't have any priority. They have to queue for the distribution of assets and money, but at the discretion of DGI. But the secure creditor is different. They have their land, mortgage, registrable interest under their name. So whatever the proceed sale of the land, the money will automatically go to their bank account. So these are the people. And who are preferential creditor? Preferential creditor usually refer to those who has priority lah. Usually who, income tax, the cukai, pintu cukai tanah fellow. Let's say the person is a sole proprietor, even the worker is so-called a preferential creditor, will get the money fast if there is any lah. I doubt there's any. Okay, so act of bankruptcy, you have to look at section 3, sub-rule 1, A to J. Okay, but our important part is this one, section 3(1)(I), Insolvency Act. Okay, this one. Okay, usually after judgment, tak bayar. So this is act of bankruptcy. The rest is dealing with property evading. I don't think this is our question lah. Okay, act of bankruptcy, and the bankruptcy notice must state the quantified sum. You cannot say 379 ringgit plus interest plus continue cost, something like that. It's totally wrong. Okay, get me? And then after that, you request for bankruptcy notice. Like I've shown you, you need to give the judgment, read summon, affidavit of service plus that judgment, of that judgment, and then the registrar will give you bankruptcy notice. Okay. Mm. Then simple thing lor, nothing pass lah. Everything must be quantified lah. Bankruptcy notice cannot be found on two different judgment. It means if I sue Mr. B for two cases, one is defamation, another one is breach of contract. One is 60,000, another one is 50,000. I cannot combine these two judgment just to reach the threshold of 100,000. Cannot. Okay. So other than that, nothing much, nothing much. Service must be personal. Lor. This one I told you. Okay. If cannot do it on time, you have to extend. If still cannot, do SS, publish the newspaper. And then this is how they set aside the bankruptcy notice. If the debtor think that they could pay, they will have offset, they will have counterclaim. You pay me, you are supposed to owe me. They can set by way of affidavit lah. But hardly lah, in practice, hardly you see this lah. You get a bankruptcy order just like that lah. Okay, after the bankruptcy notice has been issued, straight away you can file for creditor's petition. Okay, creditor's petition. And all the time, creditor's petition lasts only 6 months. Then you have to use apa nama panggil affidavit verifying the fact. This is done by the authorized person of the company, the credit card company, and it must be attached by lawyer. The lawyer must be coming from Malaya. Okay, validity of the claim, service also done personally. Then if there is any challenge, must file affidavit in reply. And in Malaysia, second bankruptcy is actually allowed, provided they clear the first bankruptcy punya asset and all that. Okay. And minimum sum now is 100,000 ringgit to fine a person. More than 100,000 ringgit, then only you can fine a person bankrupt. Less than that, paper judgment, no point. Okay, adjournment, all that no need to know lah. Reinstatement, all that also no need to know. So, effect bankruptcy order, yeah. So they cannot own any. Okay. The person that got bankrupt, apart from cannot go into overseas, cannot work without permission of DGI, they also cannot sue a person, they lost their legal ability to sue a person unless it is for personal injury claim. They have an accident, then they can sue. Okay, if they are just having some what we call defamation contractual claim, they cannot sue. They have to get sanction from DGI. So they are less freedom enjoyed by those who are bankrupt lah. But try to read all this lah. Try to read these 30 pages and my slides. I think should be okay leh. Not hard leh. To me, it's not hard lah. Because practical experience got a bit of here and there. I don't think it's too hard lah. I will send this tool to you And of course, as usual, I will send this video recording to YouTube. Together, we have a few videos uploaded by our other teacher. I will upload together to the YouTube channel a moment later. Later, you all can have free time to revise about that lah. Okay. Do you have any other question?